The dismissal order was 3 sentences long. Vivienne Okafor had spent 14 months building the case. Not 14 months of regular work hours, 14 months of evenings and weekends layered on top of Shan's regular caseload. 14 months of her documentation specialist working through boxes of records that tenants had gathered across years of living in conditions that had been documented and reported and ignored. 14 months of her attorney, Claudia Reyes, building the legal architecture that would carry the factual record into court in a form the court could act on. She had gathered 22 months of financial records from the 8 buildings, tracking Meridian Residential's maintenance expenditures and rent roll against the documented timeline of deterioration. She had 8 signed witness declarations from city code inspectors, a former Meridian employee who had agreed to give testimony, and 3 tenants from different buildings whose experiences were representative of the broader pattern. She had 3 expert opinions: a housing law specialist, an employment discrimination expert whose work she had used in prior cases, and a real estate economist who had analyzed the rezoning timeline and the property value data and produced a 40-page report on the financial incentives created by the displacement strategy. The complaint brief ran to 61 pages. The supporting documentation was 412 pages. Every page was numbered. Every exhibit was labeled. Every claim was keyed to the documentation that supported it. Vivienne had reviewed the complete package 3 times before her attorney filed it. Her attorney had filed it on a Tuesday morning in September. The dismissal order came back on Thursday afternoon. 41 hours. 3 sentences. The complaint failed to state a claim upon which relief could be granted. The plaintiff had not demonstrated standing. The case was dismissed with prejudice. No citations, no analysis, no engagement with the 61 pages. No reference to any of the 412 pages of supporting documentation. Not a single specific fact from the brief addressed. Not a single legal argument engaged with. Not a single case cited in support of either of the 2 grounds stated. 3 sentences and the case was over. Vivienne read the order once. She set it on her desk. She sat for a moment. Then she called Claudia. Claudia read the order and was quiet for a moment in the particular way of a person whose professional assessment has arrived before their words have. Then she said what she believed. That in 17 years of practice, she had not seen a dismissal order this summary produced on a complaint of this complexity. And that it was her professional opinion that the order had not been produced by someone who had read what they filed. Vivienne asked what they could do. Claudia sighed, appeal, and then she said the sentence that Vivienne would remember longest. In the right hands, an appeal of this kind doesn't just reverse a dismissal. It opens a record. Vivienne sighed. Open it. Go back 3 years. Vivienne Okafor was 44 years old, a licensed social worker who had spent 15 years building a small nonprofit organization called the Southside Housing Advocacy Network, SHAN, that worked with low-income tenants in Chicago's South and West Side neighborhoods to navigate housing disputes, connect with legal aid, and document violations in ways that produce the kind of record courts required and that most tenants acting alone did not have the resources or the knowledge to build. She had started SHAN after watching a single case. A family on East 83rd Street had been living in a building with documented code violations for 2 years. No heat in the winter, a roof that leaked into 2 of the bedrooms, a boiler condemned and not replaced, an elevator that had been out of service for 11 months. Their landlord had told them, with the casual confidence of someone who has delivered this speech to many tenants before, that their options were to accept the conditions or leave. He knew, and they knew he knew, that leaving was not a simple proposition, that finding comparable space at comparable cost in a neighborhood that still had their children's schools and their jobs and their community was not an option that could be exercised on short notice, with limited savings and no rental history at a new property. Vivienne had met the family through her social work practice. She had helped them document the violations, dates, photographs, written maintenance requests sent and not responded to, a log of the conditions in each room across 6 months. She had connected them with a legal aid attorney. She had sat in the courtroom and watched the case move through the machinery of the civil court system. And she had observed, in that process, the gap she wanted to close, the gap between people who had legitimate legal claims and the documentation institutional knowledge, and organizational infrastructure to make those claims visible to the systems capable of addressing them. Shan had served 430 families in its first 5 years. Its staff of 6 included 2 community navigators who spoke Spanish and Polish as well as English, a documentación specialist who had come from a background in paralegal work, and 2 program coordinators who had both grown up in the neighborhoods they served. The organization had a network of pro bono legal partners across 4 law firms and a methodology for documentation that Vivienne had refined over 15 years of watching what courts needed and building the practices that produced it. The case that Judge Whitman dismissed was not the largest Shan had ever been involved with. It was the most consequential it had ever brought directly to court. 47 families, 8 buildings, a single property management company called Meridian Residential, whose principals Vivienne had been watching for 4 years and whose practices across those 8 buildings had, when fully documented, a pattern that was not visible in any single building but became unmistakable when you looked at all 8 simultaneously. The pattern was this. A building was acquired by Meridian. Maintenance requests began to be deferred. Code violations began to accumulate, slowly at first, then more rapidly. The tenant population of those buildings was overwhelmingly Black, in neighborhoods that had been recently rezoned for mixed-use commercial development, which meant that the land value underneath the buildings was rising and that the economics of converting the buildings to market-rate residential or commercial use were becoming more attractive by the year. Tenants who complained received pressure. Leases non-renewal notices. Retroactive lease violations cited against them for things that had been permitted under prior management. Abrupt rent increases at the margins of what was legally permissible. Tenants who stayed through the worst of the deterioration began to receive buyout offers. Not all of the 47 families had experienced all of these things, but collectively, across the 8 buildings, every element of the pattern was documented. And the documentation traced a coherent sequence of events that, in Vivienne's professional assessment and in Claudia Reyes's legal assessment, amounted to organized predatory displacement, a systematic strategy for removing Black tenants from land that was becoming valuable. The brief laid all of it out, 61 pages of factual narrative and legal argument, 412 pages of supporting documentation, photographs, maintenance logs, lease records, municipal code violation reports, financial records, the buyout letters, the displacement timeline mapped building by building and overlaid against the rezoning dates and the property value assessments. Judge Whitman had dismissed it in 41 hours. His docket at the time of the dismissal contained 43 active cases. His 2-day administrative calendar included 2 scheduled hearings, a conference call with another judicial committee, and a recorded judicial education session. Vivienne had pulled his public administrative calendar. It was available because judicial schedules at that level are part of the public administrative record. And done the arithmetic, 41 hours, minus the time occupied by documented commitments, did not leave a window in which a person could read 61 pages of argument and 412 pages of supporting documentation and produce a substantive legal analysis. It left a window in which a person could produce 3 sentences that were not a legal analysis and were not meant to be. Vivienne had done the math before she called her attorney. Her attorney's name was Claudia Reyes, 49 years old, 17 years in practice, a civil rights and housing litigation specialist who had built her firm from a solo practice on the strength of a reputation earned 1 case at a time. She had clerked for a federal judge after law school, spent 3 years at a large firm learning how commercial litigation was resourced and organized, and left to build something whose caseload she could be proud of. The cases she took were not the profitable ones. They were the ones where the facts supported action and the people bringing them could not afford the attorneys whose fees matched the complexity. She had taken Shan's case on a reduced fee arrangement 2 years before the filing. She had reviewed the documentation with the thoroughness she brought to every case, every page, every exhibit, every date in the timeline, and told Vivienne that the factual record was as solid as she had seen in a class action of this scope. She had also told her, honestly and without minimizing it, Taracase is solid against a property management company, this well-resourced and with this much at stake in a neighborhood experiencing this level of development pressure, was going to be hard in ways that had nothing to do with the merits. She had not anticipated that the hard would arrive in 41 hours as 3 sentences with no legal analysis. When she called Vivienne with the dismissal, she did not perform the restraint of an attorney managing a client's reaction. She cited plainly what she believed, that the order was not the product of a judge who had read the filing. She cited that way because it was true, and because Vivienne had spent 15 years building an organization whose foundation was accurate information delivered clearly. And she was not going to manage that. She sighed. In 17 years, I have not seen a dismissal this summary on a complaint of this complexity. It is my professional opinion that this order was not produced by someone who read what we filed, and Vivienne had asked what they could do. And Claudia had said, appeal. The appeal brief was 38 pages. Its argument rested on 3 pillars: the substantive errors in the 3 sentences of the dismissal order, the procedural irregularity of a dismissal issued in 41 hours against a brief of this size and complexity, and the third argument that Claudia had discussed with Vivienne for 2 conversations over a week before including it. The third argument took 3 weeks to build. Claudia had pulled the public court records for Judge Whitman's docket going back 6 years, the full span of his current assignment to the circuit court. She had identified every case in that period involving a plaintiff asserting civil rights or fair housing claims. She had extracted the filing dates, the dismissal dates, and the order content for each one. She had retained a statistical consultant, a retired professor of applied statistics from the University of Illinois, whose work in legal pattern analysis Claudia had followed for years, and had asked him to run the analysis independently, without her characterization of the pattern, so that his findings were genuinely independent. The analysis took 3 weeks and produced a 12-page report. The report found what Claudia had suspected and what the raw data, once organized, made visible: a pattern of early dismissal. Dismissals issued within 72 hours of filing. That was concentrated in cases brought by Black plaintiffs asserting civil rights or housing discrimination claims. The pattern held when the statistician controlled for case complexity, for prior procedural history, and for the specific legal theories asserted. It was not explained by any of those variables. It was explained by the identity of the plaintiffs and the nature of the claims. The pattern had existed in the public record for 6 years. It had not been visible because nobody had looked at the record in aggregate. Each case was its own file, its own number, its own dismissal order. The attorneys who had appeared in those cases and lost had moved on to other matters. Nobody had stood back and looked at the whole picture. Claudia had looked. The picture was clear. The brief's third argument presented the data, presented the statistical findings, and argued that the pattern, in combination with the procedural irregularity of this specific dismissal, warranted referral to the Illinois Judicial Inquiry Board for a review of Judge Whitman's conduct under the Code of Judicial Conduct. It did not call him biased. It did not need to. The data said what it said. The Illinois Appellate Court heard oral argument on the appeal 11 months after it was filed. The panel was 3 judges. Claudia argued for 22 minutes with the precision of someone who has spent 3 weeks preparing 22 minutes of argument and knows exactly where each minute goes and what it needs to accomplish. The panel asked 8 questions across the argument, substantive questions, the kind that indicate a bench that has read the brief carefully and is seeking clarification rather than testing credibility. The presiding judge, the Honorable Patricia Amara Chen, 21 years on the bench, a reputation among appellate practitioners for the thoroughness of her preparation and the specificity of her questions, asked 2 of the 8 herself. The first was about the statistical methodology underlying the pattern analysis, specifically, what variables the consultant had controlled for, and whether the sample was sufficient to support the stated conclusions. Claudia answered precisely. The second was about the gap between the filing date and the dismissal order. She asked Claudia to walk through the documented administrative calendar and explain how the arithmetic was established. Claudia walked through it. She had prepared this answer in particular detail because she understood that the timing argument was the one that required the most careful establishment, and because a judge who was going to make a referral to the Judicial Inquiry Board needed to be certain about the arithmetic before she did. The appellate decision came 7 weeks after argument. 3 judges, 0 dissents. The panel reversed the dismissal on the substantive grounds first, finding in clear, specific language that the complaint had stated a claim that standing had been established, and that a dismissal order that failed to engage with any of the 61 pages of argument or 412 pages of documentation was not a legally adequate basis for dismissal with prejudice. The case was remanded to a different judge. Then the panel addressed the third argument. The decision's language on this point was careful and measured, the way appellate language is careful when it is building toward a referral that will have consequences. It noted the statistical analysis. It noted the administrative calendar analysis. It noted that the pattern, if accurate, raised questions about the administration of justice in the circuit court that were within the purview of the Judicial Inquiry Board to examine. It referred the matter accordingly. The referral was not a finding. It was an instruction to look. The Judicial Inquiry Board looked. The board's investigation took 8 months. It replicated Claudia's analysis independently. The same public records, a different statistician, validated with the same result. It interviewed 31 attorneys who had appeared in Judge Whitman's court in civil rights and fair housing cases over the 6-year period and received accounts from 19 of them that, in combination with the record analysis, painted a picture of a judge who had developed a practice of disposing of a specific category of cases before they could require the time and engagement that other cases received. The board presented its findings to the Illinois Courts Commission. Judge Whitman resigned 6 days before his hearing was scheduled. His attorney's statement used the phrase health reasons. The timing, 6 days before, was observed by every attorney who had ever appeared before him and lost, including 11 of the 19 who had spoken to the board, some of whom had held for years the private knowledge that their case had been dismissed before anyone with the authority to read it had done so. They said nothing publicly. The record said what it needed to say. The Shan case was assigned to a new judge 2 weeks after the remand order was entered. His name appeared in no newspaper articles and carried no particular reputation that preceded him. He was a working judge, mid-career, assigned to the circuit court civil docket, with a caseload of hundreds of cases, and the deliberate habits of someone who understood that their job required them to actually read what was in front of them. He held an initial hearing 4 weeks after receiving the case. He had clearly read the brief before the hearing, not the general shape of it, but the specific content. He asked 7 questions, all of them precise, some of them anticipating arguments that hadn't been raised yet in the hearing. The kind of questions that only come from someone who has been inside the document rather than across from it. The case proceeded through discovery, through motions practice, through the contested factual record that a case of this complexity required to be properly developed. It took 14 months, from remand to settlement. The settlement terms were not made public. Vivien's statement described it as providing meaningful and substantial relief to all 47 families. Claudia was more specific in her own public comment. The settlement included financial compensation to each of the 47 families that reflected the documented harm, a structural reform agreement governing Meridian residentials, lease enforcement and maintenance practices in the 8 buildings, and a monitoring agreement enforceable by the court, requiring third-party audits of Meridian's compliance with those practices over a 5-year period. It was not a complete victory in the sense of full damages sought. Settlements rarely were, but it was, in Claudia's assessment and Vivien's, a real result, one that put real resources in the hands of real families who had been subjected to a real and documented harm, and one that created real constraints on the company's ability to continue those practices. And it created a record. The 47 families' documentation was now in the permanent file of a case that had been adjudicated and resolved. The pattern of displacement was documented in a court record that could be cited in any future proceeding. The appellate decision that had reversed the dismissal was published, meaning it was precedent, available to any attorney handling a case in that circuit who needed to cite a basis for opposing summary dismissal of a civil rights complaint without substantive analysis. The record had been opened. It would not close. Vivien did not hold a press conference after the settlement. She held a community meeting in the church hall on East 79th Street. With folding chairs and a whiteboard and 41 of the 47 families either present or connected by video, the same way she ran every significant meeting at Shan. In plain language, with everyone in the room who had a stake in what was being described. She told them what had been achieved and what had not. She cited the word settlement plainly and explained what it meant in practice, which was that the case had not gone to trial and the damages had not been fully litigated. She cited what the monitoring agreement required. She cited what it was enforceable for and who could be called if Meridian violated it. Then she said the things she had been thinking about since the day the appellate decision came down. The things she had not said in any public forum, had not put in any press statement. Had not told anyone except Claudia, in Claudia's office, over coffee, 2 days after the remand was entered. She sighed, "I want you to understand what else happened in this case. There was a judge in this court for 6 years who was dismissing cases like yours before he read them. That pattern was in the public record the entire time. Nobody looked. We looked. We put it in a brief, and the appellate court took it seriously. And now it's in a published decision, and in the files of the Judicial Inquiry Board and in the institutional record of the state's judiciary. That judge is no longer on the bench. And the next attorney who picks up a civil rights case in this circuit and files it in this court has a record that says, 'We looked before, and here is what we found.' And the court took it seriously." She paused. "That is not justice for the years you spent in those buildings. I know that. But it is something the next family can use. And the family after that." She drove back to the Chan office. Her staff of Sikhs was waiting for the debrief, and then the transition meeting, and then the question she asked at the end of every significant case close. She asked what was next. There were 11 families waiting. She started with the first one.